Hi, I'm Dr. Bob Gill. I'm here with Dr. Chris Day, an NHS whistleblower. After 3 years of your battle, you defeated arguments to undermine whistleblowing law. What was your case about?
Well, my whistleblowing case is about essentially me saying that I raised serious concerns about an understaffed intensive care unit, and I say that the NHS decided not to listen to them and decided not to act on them, and to instead make false allegations and sort of create an employment dispute to confuse the issues. Now, just for the sake of balance, they say that that is not what happened and they've done nothing wrong. So that's the whistleblowing case.
So why has your case not been heard yet?
Well, that's what you alluded to in the Court of Appeal. So in February 2015, when I actually brought the whistleblowing case, instead of coming to court and explaining exactly why I'm wrong to say that they ignored the safety concern and caused me whistleblowing detriment, they decided to come instead and say they didn't need to come to court. And as a result, argued all junior doctors out of whistleblowing protection, and we now know from the Court of Appeal that this also had an effect on 800,000 other agency workers across other industries. Now, it is in some ways technical what they argued, but I just want to read out a quote from the judgment that really gets to the bottom of what HE were arguing. And Lord Justice Elias captures the position of HE perfectly in his judgment. And I quote him, "HE contended, even if the facts alleged by Dr. Day were true, HE could not be liable in law for any acts causing him detriment." So that's essentially HE saying that even if what I say about them ignoring safety concerns is true, even if what I say about them destroying my career is true, it doesn't matter because they're not covered by whistleblowing law.
Well, that's incredible. And one of the arguments they used was to lie about Parliament's position on whistleblowing protection for junior doctors. Can you tell me about that?
Well, I've got to be slow to accusing people of lying when I'm involved in litigation, but what we do know is in the court below the Court of Appeal, it's common ground that HE submitted that Parliament's conscious choice was to exclude junior doctors' relationship from HEE. Now, we were actually assisted in the Court of Appeal by the charity Public Concern at Work, who were actually instrumental in ensuring whistleblowing law got on to into British law. And they also helpfully provided the parliamentary transcripts, known as Hansard, for when the Public Interest Disclosure Bill ascended through Parliament. And I want to quote from the debate because it really does show what Parliament's intent was with whistleblowing law. And guess what? It wasn't to exclude junior doctors. So I quote from Hansard, "It covers individuals such as trainees, home workers and professionals in the NHS who are not normally protected by employment law." So that's pretty clear. Trainees, home workers and professionals in the NHS, even those who might not be covered by employment law, are protected by whistleblowing law. So why on earth did HEE submit that Parliament consciously chose the entire medical profession below consultant grade not to be covered by whistleblowing law, weeks after the report into mid-staffs calling for an open culture in the NHS? And this is a question they really have to answer.
Well, even more importantly, you worked in intensive care, and intensive care units look after the sickest people in hospital. They're keeping people alive using drugs and equipment, and without that care, many people would die. And your concern was about not enough staff to do this safely. So it's quite staggering that Health Education England, which looks after the training of doctors, refused to allow those concerns to be heard. Now, I understand also the GMC expressed a concern that doctors were now too scared to speak up after what happened to you.
Well, yes, I mean, the GMC, I think, has received a lot of feedback from junior doctors that are very, very upset from essentially the HE position that the law allows them to essentially do what they like when people raise safety concerns to them. You know, they can choose to listen to them or they can choose not to listen to them, and they can choose to cause a doctor detriment, and it will never ever get to court, and no one will ever really know what happens in these sorts of situations. So the GMC and we've got a quote on the screen, really just describe the effect that has happened on the medical profession and on safety.
And Health Education England were responsible for terminating your career, is that right?
Well, yeah, my whistleblowing case is that they didn't listen to the safety concerns, they didn't act on them, and they decided instead to cause me damage, which resulted in the end of my career. And that needs to be heard. And the only thing I'd say on that is I've been desperate to get this case to court for 3 years, and they have, instead of dealing with the concerns, expended vast sums of taxpayer money trying to ensure that it never gets to court. So it's up to you to decide who you think really wants this to get to court and who you think really wants the truth of this situation to be exposed.
Well, not only has there been a 4-year delay, but in February this year, 2017, there was a report into the intensive care unit at Queen Elizabeth's Hospital where you worked, and the conclusions of that report bore out that there was still understaffing in that unit. Can you tell me a bit more about that report?
Well, the report, I would say, says very similar things to the sorts of things I first highlighted to the Trust and HE in 2013. It says it's very concerned about doctor-patient numbers. It says some concerns about the handover process, and in particular some concerns because of the understaffing on how patients are cared for outside of the ICU. So they're patients that might be so sick that they need ICU but need to be cared for outside of the ICU. So again, I come back to the point that the NHS has to face the fact that it has decided instead to act on these concerns, to spend vast sums of public money trying to prevent my court case getting to court, and thus undermining whistleblowing law for other junior doctors. And again, I think they need to answer that.
And not only is it the NHS, but actually this goes up to as far as Jeremy Hunt, the Secretary of State, who you spoke to at a conference, and we have footage of that conference. Can you tell me a bit about what he had to say?
Well, I'll let Mr. Hunt speak for himself from your clip, but I would just say this, that he's been aware of the case because he actually did instruct the Treasury solicitor against me in the case. So he's had legal papers, all the legal papers for my whistleblowing case since October 2014. He actually also promised a comprehensive response in November 2014 and then swiftly changed his mind. As for what he said at the conference, I'll leave that to the clip.
So the Court of Appeal ruled that the arguments advanced by you and HE were legally flawed and essentially threw them out a few weeks ago, which you may or may not be aware of, but I'm sure you are. How is that consistent with anything you've said?
Well, first of all, I know that you've championed the issues around whistleblowing consistently over a long period of time. And from my perspective, one of the central changes that I want to make in the NHS is to make it a more open system where it's easier for people to speak up when they have concerns. And that's why, after the Francis report, I commissioned Robert Francis to do another review, the Freedom to Speak Up review, which was precisely designed to look at these issues, and why, for example, we now have Freedom to Speak Up guardians in every trust. So the direction of policy that I'm trying to achieve is one where it's easier for people to speak out. Now, I'm not pretending that sometimes you have legal judgments that don't make things more difficult or take things in a different direction to the one that you intended. But I will, of course, take away those issues.
So this case is extremely important. Chris has been raising concerns about understaffing and the effect of that on patient care in a very critical situation in intensive care or critical care units where patients' lives are on the line. And we would like you to share this video, find out more about the case. You can go to Chris's website, the details will be on after this video, and support his crowdfunding appeal. Thank you very much.